Mr. Dewitte, I wouldn't make any facial expressions or motions or anything. You have an attorney who's capable of arguing whatever they need to argue for you. Statements.
I understand
And then
that.
the judge who signed the capias. Mr. Dewitte, if you can't behave and
No,
conform,
I
then
can, Your
we'll
Honor.
remove you,
No, Your
okay?
Honor. I'm sorry, Your Honor.
So,
My concern is this, I know we don't know anything.
writing within 30 days if you cannot afford an attorney. Good morning. All right, Mr. Ledan, you're here for Mr. DeWitt.
Yes, Your Honor, I'm merely down on behalf of Mr. DeWitte.
Okay, and was he already seen on the other, because he was ROR'd, so he wouldn't, okay,
I
so
was
he wouldn't
informed he
have
was
been
ROR'd.
seen by that.
Right.
Can you just state your name for the record for me?
Yes, Your Honor. It's Jeremy Charles Dewitte, Your Honor.
All right, Mr. DeWitt, looks like you came on the docket because you have a number of out-on-release cases, and so that's why they held you, even though you were ROR'd on the new law.
Yes, sir.
And so, I don't know.
Your Honor, the state is
Can
requesting
you
that
just-
Mary Lynn Honeymeyer for the state. The state's requesting that the defendant's bonds be revoked on his 3 prior cases.
How can I revoke bonds when the offense date occurred?
This offense date occurred afterwards, Your Honor. The defendant was arrested on September 7th, 2019. When the defendant was here last time, the defendant misrepresented to the court that all these offenses happened prior to the 9/7 offense date. That is not the case. So the first case he was arrested on was 2019 CF 12733.
Right, and he was seen by a judge on the 8th, correct?
Yes.
Okay.
And then the case for 2019 CF 15055, the offense date for that was September 16th, 2019.
But he hadn't been seen by a judge.
And that he was not arrested at that date, but that was when the felony offense took place. He was then seen by a judge when the defendant represented to the judge at initial appearance that this 15055 case happened before. It did not happen before. And this case that he's here on, 20 CF 1853, happened on October 1st, 2019. So again, after the September 7th, the cases where he has been out on bond. When he was seen by a judge on September 8th, he was on release for that. And he has consistently picked up new law offenses since that September 7th date.
I mean, I understand that I could revoke on the 19 case. I don't know how I could revoke if he hadn't been seen by a judge
So that would be
before
the-
this offense, because the new law offense is alleged to have occurred
October 1st, Your Honor.
October 1st, yeah, so.
So the state would be requesting that his bond be revoked on the one that he was out on bond for.
Because you said bonds.
Sorry, Judge.
Okay, all right, because that's why I was trying to figure out what you meant.
Yes.
Because I don't think I can revoke on the other cases.
The other ones, Your Honor, the bonds can stay the same, but the one that he was out on bond for at the time, the 2019 CF 12733, the state is requesting that that bond be revoked.
All right, Mr. Leton, do you have any argument?
Yes, Your Honor. So I agree with the court's analysis and was going to raise that issue, but it's been resolved, so I'll pass to the next issue for me. All of these cases flow from video that was taken from my client as a result of his arrest in Windermere. We're not here to litigate that case, but for the court's consideration, one of the main elements of this offense that's alleged is that my client intentionally intercepted conversations. And what I think it's important for the court to understand for today's purposes is this. Mr. DeWitte operates a business that uses body cameras. Those body cameras are on all of his uniformed personnel that operate these funeral escorts. Those body cameras are always running. So in the event that law enforcement obtained these videos and is now going through systematically to find what else they can potentially charge my client with, what they're finding are those recordings. And so the issue of intent is really what's at stake here. I don't know that there's any way we're going to get to the bottom of that today, and don't expect the court to make that assessment, but I think before you revoke this man's bond and keep him in jail, I'd like you to at least consider the fact that that is the source of this audio. And
Isn't this a recorded phone conversation?
correct, but anytime it's a helmet cam and a body camera. So anytime it's running, if he makes a phone call, it's going to record it.
Your Honor, if I may, I don't believe that this was body-worn camera footage that was recording
Yeah,
in this case. I have seen the audio of it. It isn't from the defendant's body-worn camera. That's my understanding. So I understand what the defense is saying, but that is an argument to be made not of whether or not his bond should be revoked, but an argument of whether or not there's PC, which has already been found, essentially.
Okay, because I mean, based on one of the affidavits, it says that I reviewed the above-mentioned disc that they received from Chief Edwards, which he obtained from Detective John Allen with the Windermere Police Department, and the disc contained an audio file of a recorded phone conversation that took place on October 1st between a person who identified himself as the defendant, a crime scene analyst, and the individual, looks like Gregory Fosterino. So I don't know whether, Mr. DeWitt, I wouldn't make any facial expressions or motions or anything. You have an attorney who's capable of arguing whatever they need to argue for you, okay? So I don't know if it's a body camera, helmet, whatever is being recorded, but it appears as though it's some sort of a recording of an audio file from a phone conversation. So I don't feel like I know enough about what happened, but it's two sworn statements.
I understand
And then
that,
the
so-
judge who signed the capias, Mr. DeWitt, if you can't behave and
No,
conform,
I
then
can, Your
we'll
Honor.
remove you,
No, Your
okay?
Honor. I'm sorry, Your Honor.
So,
My concern is this, I know we don't know enough about it, but my
Yeah.
point is simply this. These are all videos, we could be in this position tomorrow, next week, next month, because they're going to continue to review this
I never
conduct.
saw him on any other case.
Right.
I know that Judge Carter, I believe, did, and
She
maybe
did.
some other judges, so I
Correct.
don't know.
And so what-
I don't know anything about the facts of any of the underlying cases either.
Well, they all flow from this Windermere arrest. So however the audio was obtained, it was obtained from my client's business records that are maintained on his person and on every one of his employees. And so my point is simply, I think it's a bit disingenuous to say definitively that he's out on bond committing new law offenses when the sourcing of this is directly from the recordings that are maintained through his business. So I'd rather have an opportunity to have my client out on bond where he can assist me with his defenses and to continue to represent him in that capacity than have him in custody. One. Two, his wife is how many months pregnant?
She's 20 weeks.
Okay.
And this our third, well, it's our first baby, but our third chance.
She's had 2 miscarriages previously, so there's a lot of medical issues going on at home. There's a lot of stress that's related to the pregnancy in light of the prior miscarriages. So while that's not necessarily an issue of the lawfulness of revoking the bond, I do want the court to at least be mindful of where he is and what we're trying to do. Mr. DeWitte has not done anything in months to do anything in opposition to the law. I'm monitoring everything that we're doing on these cases, and they all do have a potential issue based on what Windermere did in that first case, which we'll be litigating, but it's going to take time and money and effort to do those things, and none of those things are going to happen if he's in jail. So I really need him to be out.
All right, any last argument?
Your Honor, so the state's argument is that the defendant has violated his conditions of pretrial release and that there are no conditions of release that can reasonably protect the community from risk to physical harm to persons. The defendant is continuing to be a risk to the community. His business practice continues to be a risk to the community. The defendant is consistently picking up felony charges while out on bond. The defendant's bond should be revoked for those reasons.
Okay, so you can file a motion to revoke bond and let the trial division determine that, but I'm not going to revoke his bond today. And so you have motions that you can file, but I'm not going to revoke the bond based on the affidavits, and because I really don't know where the information came from and when it came from, and I just don't feel comfortable doing that because I don't know enough. So, but you have the opportunity to file any appropriate motions in the trial division, and looks like the only case that the bond could be revoked on would be the 19 CF 12733, based on the dates of the offense, possibly the one in Osceola County, which I'm not gonna take any action on that either. That's 2019 CF 3928. So it looks like there's two cases that possible that a bond could be revoked on, but I'm not gonna take any action today, okay?
Yes, Your Honor, thank you.
Thank you very much, Your Honor.
All right. All right, good morning. Tell me your name, please.
Good morning, my name is Rafael Antonio Baez.
All right, Mr. Baez, you're here in 2020 CF 1942AO. You're arrested for possession of cannabis with intent to sell or deliver, possession of cannabis, more than 20 grams. I do find probable cause. I'll appoint the public defender, no drugs or alcohol without a valid prescription. I am going to stay the bond at 1,000 on count one. I'll ROR